Hello there, my name is Abdul Ali and I'm a drink driving lawyer here at Padel and Peel Solicitors. In today's video we'll be talking about failing to provide and the usual defences that we use to help clients keep their driving licences. Now let's begin with understanding what failure to provide means, because that's important. Now this offence occurs when a motorist refuses to provide a sample of breath, blood or urine for analysis. Now many motorists mistakenly believe that there are laws preventing the police from conducting these tests. However, if the police have reasonable suspicion, and that's the key word here, reasonable suspicion, they can request these samples. Now the legislation is contained within the Road Traffic Act 1988, and it states that in the course of an investigation into whether a person has committed an offence under the relevant sections 3A, 4, 5 of the Act, a constable may require him to provide a specimen of breath for analysis by means of a device approved by the Secretary of State, or provide a specimen of blood or urine for a laboratory test. And failure to do so without a reasonable excuse, in essence, is an offence. Now let's discuss the preliminary test versus the evidential test. Now let's discuss the difference between a preliminary test and an evidential test. Now, failure to provide offences can be split into two main categories, evidential and preliminary. Initially, you'll be asked to provide a preliminary sample at the roadside, following the police officer stopping you. If the reading exceeds a legal limit at this stage, you'll be taken back to the police station for an evidential breath test. Here, you'll provide 2 samples of breath for analysis, and the police will consider the lower of the 2. Remember, the preliminary breathalyzer result is not admissible as evidence in court. Failing to provide the preliminary breath test, albeit is an offence, however, it's not as serious as failing to provide at the police station. Now, failing to provide an evidential breath test at the police station, this is somewhat different. If you fail to provide a specimen at the police station without a reasonable excuse, this is a more serious offence under Section 7 of the Road Traffic Act 1988. A conviction can lead to a minimum of 12 months driving disqualification, which may increase to 36 months if you have any prior drink driving related convictions. Let's discuss defences to failure to provide at the police station. As you probably recall, I mentioned reasonable excuse previously. Now let's discuss reasonable excuse for failing to provide a specimen. This is a crucial part of your defence, as the law does allow for certain valid justifications in these type of cases. Now, the first category is medical reasons. If you have a medical condition such as asthma, COPD, or a severe allergy to substances like alcohol or antiseptics, you may be unable to provide a breath sample. In such cases, it's vital to have a medical documentation to support your claim. A letter from your doctor detailing your condition can significantly bolster your defence. Now, mental health issues is also important, and if you suffer from mental health issues such as severe anxiety, PTSD, or any other medical condition for that matter, this can inhibit your ability to provide a sample. It's essential to present evidence from a qualified mental health professional that illustrates how your condition affected your actions during the encounter with the police during the procedure. Procedural errors can also serve as a reasonable excuse. If the police did not follow the correct procedures at the police station, such as failing to provide you with a statutory warning, which is discussed in one of our previous videos, or not informing you of your rights, you may have grounds for dismissal of your charges. Certainly, you will have a defence. Another aspect to consider is technical errors relating to the breathalyzer or the testing equipment. Now, for instance, if the device was not calibrated correctly before your test, this could invalidate the results. Evidence from a qualified technician or independent tester can demonstrate this failure and support your case. Now, in any of these situations, having an experienced solicitor can make all the difference. We can help gather the necessary documentation, build your case, and present a compelling argument to the court. Remember, every case is unique, and the circumstances surrounding your situation will heavily influence the viability of a reasonable excuse. You may be wondering why Parnell and Peel? What makes us different is, number one, our experience, and number two is the hands-on work that we do. Remember, we've been dealing with failing to provide cases for a number of years. There isn't a case that we've not come across. And we use all of this experience ultimately to help you keep your driving licence. Thank you for watching. Please remember to like, comment and subscribe for more free legal content.